Hello, everyone. Welcome back once again. Thank you so much for staying tuned with us. We are joined by Fareen Jamal and Katerina Tempestra, who will be our panelists, and they will speak on the removal, retention of children across international borders. Our panelists will talk about non-Hague cases. Before I hand things over to our panelists, I'll just quickly go over our agenda just so our audience has an idea of what to expect in the next hour. How are cases involving non-signatory countries different from Hague cases? What is the relevance of the child's habitual residence in non-Hague cases? How is the child's habitual residence determined in these cases? What options does a court have when it determines that a child has been wrongfully removed from a non-Hague country, is being wrongfully retained in Ontario? If an Ontario court determines that the child is habitually resident in the non-Hague country / non-habitually resident in Ontario, can it still assume jurisdiction? How is the test for serious harm under Section 23 of the CLRA different from the grave risk exception under the Hague Convention? What factors are relevant to the assessment of serious harm under Section 23? What is required to establish foreign law as a source of serious harm? What is the role of undertakings in Section 40 written cases? What are the timelines for hearing these cases? Is there a difference between Hague and non-Hague cases? How do rights of children factor into alleged international abduction cases, including the right to be heard? What happens when the child has been found to be a convention refugee in Canada, or is there a pending refugee claim?
Thank you so much. Wow, that's a formidable list. Why don't we turn to non-Hague countries now? How do we deal with those cases, and how are they different from what we've been learning about?
So non-Hague countries are where they are not a signatory to the Hague Convention or haven't acceded, right? And undertakings is one of the first ones, just like Kathy was saying, right? Like enforcement of undertakings with a non-Hague Convention country is impossible, is unknown, I should say. With a Hague country, you've got reciprocity. You've got assurances that undertakings will be respected in another country. You don't have that with a non-Hague country, right? And so counsel and even sometimes the judiciary fail to recognize fundamental differences between return applications under the provincial legislation in Ontario, the CLRA, and those under the Hague Convention. For return applications involving non-signatory states, there's no basis to assume that the receiving state is going to determine parenting rights based on a child's best interests, right? And a lot of these non-Hague countries haven't signed up to the Hague Convention because they cannot guarantee a presumption of a child's best interests being their legal system is different. They may have presumptions, until a child is a certain age, it's assumed that mother will have custody, and after a certain age, dad will have custody, or parenting rights, custodial, what we think of custody, parenting rights, decision making is allocated differently, and they cannot guarantee that a child's best interests would be the presumption or the paramount consideration. Under the Hague Convention, application of best interests is warranted by contracting states. And Canadian courts have refined the manner in which we treat wrongful removal and retention cases from non-Hague cases. The most recent is the Supreme Court of Canada decision last year in FVN, which I was fortunate to be involved in. We represented the mother who was here, and Kathy was involved, the OCL was involved. There was a number of interveners involved at the SCC level. The OCL was involved at the Court of Appeal also. And it was a split decision, 5-4, right? Justice Kazra writing for the majority, Justice Jamal, no relation, writing for the dissent. Obviously, I like the dissent more than the majority, but it was 5-4. It was a close call, and they sent the children back, very young children. But there is, there's a focus on it. They're thinking about what does the role of best interest, the principle of best interests, how does the role of the principle of best interest apply in these cases? Non-Hague cases have a number of distinctions, right? You don't, in Hague cases, there is a mandatory return. You must return them. That's what the Hague Convention says. Under Section 40 of the CLRA, you don't. In fact, the words habitual residence don't even exist in Section 40. Instead, what you're doing is returning children to a place that is appropriate, right? Article 12 of the Hague Convention obliges a court unless there's grave risk, whereas Section 40, may. It doesn't automatically follow. You may return them to a place that is appropriate. And as we'll talk about in a little while, in Galaden and Gouda, it wasn't either of the two countries. It was a third country completely, right? So there's some, you're returning the children to a place that is quote unquote appropriate, and an appropriate place is how the legislation references that. And also, the Supreme Court of Canada has held that courts shouldn't use their Section 40 powers to indefinitely postpone the return of a wrongfully retained child. But that might be where you're trying to make sure that undertakings are going to be fulfilled. Like Kathy was saying, they're just that, undertakings. So maybe we're waiting for fulfillment of various things before we return. As I'm sure Kathy will point out, when we come to serious harm, there's also lower standards for risk when it comes to non-Hague cases than Hague cases. So best interest is one piece. There's a lower threshold for harm. There's different factors. We have case law that does give us factors for non-Hague cases that we'll come to. And then what about inconsistencies between family law and the foreign jurisdiction in Canada? And in non-Hague cases, there is some consideration for that. So those are the major differences. And then undertakings, of course, that we just spoke about, because they're harder to guarantee, to enforce in non-Hague cases.
Okay, so let's talk a little bit about habitual residence. How is that different in non-Hague cases?
So that's what I was talking about, right? You don't, in Section 40, the return section, you don't actually have the words habitual residence at all. So it doesn't operate in the same manner, because unlike the Hague Convention, the court is given broad discretionary powers when determining what order would remedy a wrongful removal or retention in Ontario. But habitual residence does come into play in the initial jurisdiction clauses. So the question that I was going to answer is, what options do you have when you have a non-Hague case, so that we can work through what are all of our pieces, because habitual residence plays into some of them. So your first soldier is Section 22, okay? Section 22 1A, which is if a child is habitually resident in Ontario at the commencement of the proceeding, then the CLRA says Ontario can assume jurisdiction, right? And it defines habitual residence as a child being that was either A, living with both parents, or B, if the parties are separated, living with one parent under a separation agreement, court order, or consent, implied or acquiescence, or with a person other than a parent on a permanent basis for a significant period of time. Okay, so you've got a specific definition of habitual residence under 22 1A, and the section is rarely satisfied because children have not been in Ontario for a very long time when these applications commence, or there's a lack of consent demonstrated by the fact that the left behind parent has commenced an application for a return of the child. So your next soldier is 22 1B. If the child is not habitually resident, the court looks at 6 separate criteria, all of which have to be satisfied, which include, the presence of the child in the province, connections between the child and the province, and it's a cumulative, are there other orders from a different jurisdiction, and it's cumulative, all 6 factors, all 6 criteria being considered. Your next sort of option or soldier is Section 23, the serious harm exception. And that's one where we're going to spend a lot more time talking about it. But essentially, it's if the child is present and on a balance of probabilities, the court is satisfied that the child would suffer serious harm if they remain or return to the care of the person entitled to custody. So every province in Canada has some version of a serious harm exception that was enacted into legislation. And then your last one is a parent's patriarch jurisdiction. It's the court's inherent jurisdiction. And you want to be careful about invoking this section because it's meant to address legislative gaps. But if you're pleading these, that Section 69 of the CLRA gives you that soldier as well. Okay, and then if one of the above 4 sections cannot be made out and it's satisfied that the child has been wrongfully removed, then you exercise options provided under Section 40, the return provision.
Why don't we move on to the test for serious harm? How is that different under Section 23 of the CLRA versus the grave risk exemption under the Hague Convention?
Okay.
Yeah. Who wants to talk about that one?
So maybe I'll launch into that if that's okay, Maureen. Okay, So we did hear that the test for grave risk under the Hague 13(1)(b) exception is quite a high threshold. And that's, again, because you're dealing with countries that are both signatories to the Hague Convention, where there is a presumption that the best interest of the child is the test that's applied in parenting decisions. The test with respect to serious harm under Section 23 of the CLRA as a reason not to return the child is a lower threshold. That's what the Court of Appeal has held, and it was confirmed by the Supreme Court of Canada in FNN. And the reason is, because you can't have the same confidence that non-Hague countries are going to be making decisions or giving paramountcy to the best interests of the child in parenting decisions. There is no reciprocal treaty enforcement. And the language of intolerable situation in Section 13(1)(b) of the Hague Convention imports a more stringent standard than serious harm under Section 23. So that was the holding of Justice Laskin and Ojikiri in 2018, Court of Appeal, which was followed in Jeladan and Rada, another Court of Appeal decision from 2020. And then Ojikiri, as I suggested, was cited with approval in FNN by the Supreme Court of Canada. So the threshold, bottom line, is lower with respect to serious harm in non-Hague return cases than in Hague Convention cases. What are the factors that a court considers in determining serious harm? Well, again, the Court of Appeal for Ontario and Ojikiri set out a number of the factors relevant to serious harm, and not surprisingly, it includes the risk of physical harm to the child, the risk of psychological harm, the views of the children, which can be linked to the psychological harm piece. In other words, if the child's views are ignored, that may create psychological harm to the child. The parents claim that they would not return to the habitual residence, even if the child is required to do so. Now, there is a slight distinction there between cases where a parent, a taking parent, is simply saying, I'm not going to go back. I can't, I don't want to go back, which is described as a self-imposed, restriction, as compared to situations where the taking parent really faces barriers to return, such as a lack of immigration status, a lack of ability to find employment, those kinds of factors that are potentially beyond the control of the taking parent. Another factor that may go to the determination of serious harm is the laws applicable to parenting decisions in the foreign jurisdiction. And that's a big factor, again, when you're talking about non-Hague signatory countries, which may not employ best interests as the deciding factor, and which, for example, in the UAE and in some other countries like Kuwait and Jordan, there are some presumptions in the law with respect to guardianship, which equates to decision-making authority here being given to the father, as that is what the law says, and with respect to parenting time being given, for example, to the mother while children are younger, and then it's switching to the father at a certain age as the children get older, and those ages differ depending on the country that you're dealing with. So those kind of gender presumptions in foreign law could give rise to a serious risk of harm, according to the Supreme Court of Canada in FNN. But it's going to depend on the application of those laws in that jurisdiction. And this is where things get a bit complicated in terms of the tight timelines of these cases, in terms of trying to adduce evidence around the application of the laws in another jurisdiction, the need for expert evidence, dueling experts. It can get complicated. In the end, I think, and Farine, you can obviously weigh in on this. in FNN, the issue of different interpretations of the application of the law in the UAE by the experts at trial ended up being a significant factor in the trial judge's decision to return the children to the UAE, which was ultimately upheld. But that is one of the factors in terms of the serious harm determination. The other thing that the court in FNN said that those serious harm considerations under Section 23 must be child-centered and individualized. The focus is on the particular circumstances of the child rather than a general assessment of the society to which the child would be returned. Again, the views of the child are relevant, as confirmed by the Supreme Court. The separation of a young child from a primary caregiver can pose a risk to the child's psychological well-being that rises to the level of serious harm. It will not always be the case, according to the majority, but it is a consideration. The minority would have determined that that risk of separation was enough to rise to the level of serious harm. And again, the courts have to look at all potential barriers to the taking parent in terms of a return, as I mentioned, including risks to safety, employment issues, immigration issues, because if that could lead to a separation of a child from the primary caregiver, that could rise to the level of serious harm. So Farine, you may have lots to add to that.
I'm in two minds. So listen, Kathy covered it absolutely perfectly, right? Like she's covered all of the factors. She's been incredibly balanced in her approach, which is excellent. In fact, the dissent and the majority actually agreed on the principles, even the fact that, and so the laws changed, right? Even the fact that the Supreme Court of Canada recognizes that a child's loss of contact with a primary caregiver who cannot return to the home jurisdiction for reasons beyond their control can be a source of serious harm for an infant. They recognize that that could rise to serious harm. One of the factors that judges should not take into consideration in deciding jurisdiction is comparing the living conditions that each country may offer. So all of the factors that Kathy said, that was the only factor I was going to add to. I wanted to touch on this issue of the application of foreign law a little bit, because and in our case, just like Kathy said, based on the experts, when you're considering arguments regarding the application of foreign law, as long as best interests are being applied, a difference in the legal regimes will not amount to serious harm unless the foreign law is profoundly irreconcilable. Okay, so I'm going to give you the Supreme Court's own words at paragraph 88. Nonetheless, there may be instances where foreign laws are so profoundly irreconcilable with Ontario law that remitting the matter to the foreign courts would constitute serious harm within the meaning of the CLRA. And drawing the line between what is acceptable and what is not is a delicate exercise. The proper approach recognizes that inconsistencies between legal and foreign legal regimes will usually not amount to serious harm if the best interest of the child principle remains the paramount consideration in all decisions concerning children. However, if the incompatible rule automatically applies in a manner that supersedes the best interest of the child, this will be a determinative factor in the serious harm analysis when Section 23 is read in light of Section 19A of the CLRA. And I think that's the best way to put it.
And it's, again, without injecting our own perspectives on this, it's interesting also to look at the dissent in the Court of Appeal on that issue of foreign law. And I think Adam this morning referred to Justice Lauer's dissent and how all the decisions, both at the Court of Appeal and at the Supreme Court, were quite eloquently written. And Justice Lauer's identified that on the issue of serious harm, one of the factors was the unacceptable nature of the allocation of parenting responsibilities between the father and mother if the situation reverted to UAE law. So he would have found that those gender presumptions in UAE law would have been a factor in the serious harm analysis that pointed to it being or creating that risk of serious harm.
Thanks so much, ladies. Okay, why don't we talk about remedies that are available under Section 20? What are the role of undertakings in these Section 40 return cases?
So it's Section 40 that we're talking about of the CLRA. And the court only has jurisdiction under this section if a child is wrongfully removed or wrongfully retained in Ontario. And there are 3 remedies available under Section 40 to a judge who declines jurisdiction over custody. First, a judge can make an interim custody order in the best interest of a child in order to arrange for their care until a final decision is made on the merits or until it can be enforced. So even if I was before Justice Bennett, and he said, Mr. Mull, aren't you speaking out of 2 sides of your mouth? You're looking to have summer parenting time or some time this summer for your client, but you're also seeking a return. And I said, no, actually, it's provided for in Section 40. I just want to have some parenting time while we're still figuring out the bigger piece. And so it's provided for. That's the first thing. The second one is that a judge can stay an application on conditions which allows them to delay a child's return until they're satisfied that proper arrangements have been made and that a competent authorities are seized of the dispute. And finally, a judge can order the return of a child to a place they deem appropriate, right? And if a court finds that there's no risk of serious harm and refuses to exercise jurisdiction under Section 23, a return order does not automatically follow, right? It's what the court may do. And I spoke about that earlier. For example, in the case of, I don't know if it's Geladen and Rauda or Geladen and Rauda, I apologize if I'm mispronouncing that. But in that case, right, you had the UAE and Canada, but there had been a prior court order in the UK. So the court said, actually, we're remitting this to the UK so that the UK can make another court order. So it was neither of the 2 countries. And at the end of the day, the child actually ended up staying here because they never went back to the UK to change the order. So it was a creative way to come around the situation. But it just underscores just how broad the court's discretion is at this stage of the analysis. It's not the same as a Hague case. The powers are definitely broader. And the role of undertakings in Section 40 is curious, right? Because it's not like, how can you confirm that they're going to be enforced? How do you have any assurances? What if they're not? What if they're not enforced in the other country? What if the other country, their laws will apply differently? So these are real risks and considerations in non-Hague cases. Kathy, anything else you wanted to add there?
I mean, no, other than to just emphasize that there's a lot more flexibility with respect to Section 40, the types of orders that can be made under Section 40 as compared to Hague cases, which, once there's been a determination that the child's habitual residence is the country of origin and that there's been a breach of custody, the presumption is that the child goes back under Article 12, unless one of the exceptions applies. And there's a question in Hague cases, I think, as to whether the court hearing the application has any ability to make interim orders. And in Thompson, the Supreme Court of Canada suggested that perhaps courts do not, although it did talk about, the majority did talk about the court's ability to control its own process, for example, with respect to making undertakings. But that's a bit of I think, an unresolved issue in law in terms of the court's ability in Hague cases to make interim orders, whereas it's fairly clear under Section 40 that the court has that ability. And again, because we could potentially be dealing with a country whose perceptions of best interests of the child are quite different from ours, and there may need to be more flexibility in imposing interim measures to protect the child.
Let me just add, and this is actually to the issue of harm and the factors. And this was actually an argument that the OCL made at the SCC incredibly eloquently, which is about mitigating factors that could alleviate harm to a child. And FEN definitely looked at this as well. And I really like the analysis that the dissent gave for this piece. We're not wanting children to suffer serious harm and then look at mitigating factors. or looking to alleviate them, right? Like that's, the argument was, well, there's mitigating factors for any harm of being separated from their primary caregiver. There'll be nannies there are alternative caregivers. There's an aunt who didn't know the children, or there could be care of a nanny, but the dissent says that doesn't reasonably mitigate the harm to the child. And called, it said that this is of trifling significance. That was the wording that Justice Jamal used, so I like that aspect as well. Think about that aspect when you're thinking about serious harm also. Kathy, I'm stealing from you from the SEC. Did you want to add anything? I just didn't want the audience not to hear that part because I just loved that argument.
Thanks, Farine. Yeah, and I mean, although we cited, we made that submission, right, that we should be looking at preventing harm to the child rather than mitigating harm after the fact. It was not, it was taken from a decision, Young and Young, which is well known to family law practitioners, and a statement of Justice Lura Dubé in that decision. And Justice Jamal sort of adopted that in his dissenting opinion in FNN.
Thanks so much, ladies. We seem to have made up our time. We're only 3 minutes behind, so great job. So how do the rights of children factor into alleged international abduction cases, including the right to be heard?
Okay, so I mean, you may have picked this up from my comments at various points in this presentation, and we certainly heard about it earlier today in the Voice of the Child segment, that children have a number of rights, human rights under the UN Convention on the Rights of the Child, which Canada ratified in 1991. And was involved in the drafting of it. So, we are bound as a country to implement the rights of children under the UN Convention, which includes some fundamental rights that are contained in the convention, including the child's right to be heard under Article 12, and best interests as a primary consideration in all decisions affecting children under Article 3. So, I mean, that from the OCL's perspective, and I think it's been confirmed, well, it has been confirmed in a number of appellate decisions, including decisions of the Supreme Court of Canada. The convention should be looked at in the context of statutory interpretation of whatever legislation we're looking at, including cases arising under the Hague Convention and cases that don't involve Hague countries. So when looked at from that perspective, children have the right to be heard in all of these cases, and it's a non-discretionary right. And it's also reinforced by Section 64 of the CLRA, and Section 64 applies also to Hague cases, which are under the same part. And that non-discretionary right of children to be heard in all matters affecting them, and not just parenting decisions, has been confirmed in a number of decisions. A very significant Yukon Supreme Court of Canada, Supreme Court decision in BJG and DLG in 2010, which was cited with approval in Medchuk and Medchuk, a 2019 Ontario Superior Court decision, where both of those courts emphasize that there's no ambiguity in the language used. The UNCRC is very clear. All children have these legal rights to be heard without discrimination. It does not make an exception for cases involving high conflict, including those dealing with domestic violence, parental alienation, or both. And this right to be heard was also emphasized by the Court of Appeal for Ontario in MAA and DEME, which is a non-Hague case from 2020, where Justice Bonato, writing for the majority, indicated that the right of children to participate in matters involving them is fundamental to family law proceedings. Canada has adopted the Convention on the Rights of the Child, effectively guaranteeing that their views will be heard. A determination of best interests, which is engaged in all child-related matters, must incorporate the child's views. So that was, as I said, was in the non-Hague context. In the Hague context, Certainly, the child's objection to return is, one of the ways in which the child's views is directly relevant. But as I suggested earlier, children's views are also relevant to some of the other issues that need to be determined in Hague cases. So the issue of habitual residence, as confirmed by the Court of Appeal in Ludwig, the issue of settled intention. If the child has been here for more than a year before the left behind parent begins their application. The child will have information to share about their links to the different jurisdictions, whether it's on the issue of habitual residence or settled intention. The child may have input on the issue of whether a parent was exercising rights of custody based on what was happening in their day-to-day lives when the parents were together, or even post-separation. So children's views are relevant to many of the issues that come into play in both Hague and non-Hague cases. So that right to be heard really needs to be, it needs to be respected. And the Supreme Court of Canada in Michelle and Graydon, which I'm sure everyone is familiar with, which involved a retroactive child support issue, confirmed that today children are viewed as individuals who, as full rights bearers, must have their needs and their rights respected, essentially. So in terms of, giving meaning to the child's right to be heard in these difficult cases of alleged child abduction across international borders, the question becomes, what is needed to ensure that not just that children are tokenistically given the right to be heard, but that their views are given due weight, as Article 12 of the UN Convention requires, and that ensures that they're able to express their views in all judicial proceedings that affect them, which again is required under Article 12. And the UN Committee on the Rights of the Child, which is the UN treaty body responsible for monitoring implementation of the UN Convention on the Rights of the Child in Canada, has issued a number of general comments, which are documents that basically elaborate on how the rights under the convention should be implemented. And they talk about various procedural safeguards that are necessary to ensure that children's best interests are kept at the forefront of decision making. And one of those procedural safeguards that the UN Committee on the Rights of the Child has identified is the need for legal representation for children. So that was in general comment number 14, which deals with the child's best interests. And they specifically said that the child will need legal representation when their best interests are to be formally assessed and determined by courts or other equivalent bodies, and that they need a legal representative in addition to a representative of their views. In general comment number 5, the UN committee, which focused on the general measures of implementation of the convention, the committee emphasized again that for rights to have meaning, effective remedies must be available. And for children, this includes the need for legal and other assistance. And then there are other UN treaties which emphasize the right to due process, which applies to all persons, including children, including the International Covenant on Civil and Political Rights, which talks about the right to legal personality and the right to a fair trial, which encompasses both civil and criminal proceedings. Children are encompassed in that convention. And our courts, again, have emphasized this and the impact of these abduction proceedings on children. So in AMRI and KER, which I referred to earlier, which involved a child who had been found to be a convention refugee here in Canada by virtue of abuse by her mother in Mexico, she was not heard in the initial Hague application. She did not have counsel. And was not given notice of the application. And in overturning the return decision, the Court of Appeal indicated that an order under the Hague Convention has a profound and often searing impact on the affected child, and where the proposed return engages the child's Section 7 charter rights, i.e. to security of the person, meaningful procedural protections must be afforded to the child, which includes the right to receive notice, adequate disclosure of the case, a reasonable opportunity to respond to the case, a reasonable opportunity to have their views on the merits of the application considered, and the right to legal representation. So, looking at this from a child rights perspective, children in these complex cases and the issues, as you would have heard today, and as you may appreciate if you've done these cases or are thinking about doing them, are complex. And without legal representation, there's no guarantee that the child's rights will be adequately protected when you're talking about dueling parents who, have their own sometimes agendas to advance in these cases. And this need for children to have legal representation suggests that all methods of hearing from children are not created equally. Although we can get children's views before the court via views of the child reports, via judicial interviews, via Section 30 assessments, that's not the same as legal representation and the child having a representative throughout the legal process to represent and advance their interests. And often those interventions, although they're something, they're better than not having the child's views before the courts, are a snapshot in time. And again, don't ensure that the child's fundamental right to due process is respected. So I would suggest that in these kinds of cases, legal representation is necessary, just as it would be for a parent, to ensure that the child's rights are adequately protected.
Thank you so much, Farine. Did you want to jump in? I don't want to cut you off.
No, Kathy is the authority on child's representation, and I think it's important. I really like the rules changes that notify the OCL of every one of these cases, because I think it's important in these cases. I think it adds a dimension that has been lacking.
Thank you so much. Okay, last question. What happens if a child has been found to be a convention refugee in Canada, or there's a pending refugee claim?
Okay,
so all yours, non-refoulement.
Yeah, so I mean, essentially, the case that determined that issue was the AMRI and KER case, which, as I mentioned, involved a teenage child who had been found to be a convention refugee here in Canada based on abuse by her mom, and her mom was the parent applying for her return under the Hague Convention. And so on appeal, the Court of Appeal for Ontario determined that once there has been a positive refugee determination, that creates a rebuttable presumption against return. It, creates the assumption that the child would face persecution if they were forced to return to the country of origin. So that means that the left behind parent has to overcome that burden if they are seeking return once that positive refugee determination has been made. And the decision of the Ontario Court of Justice in Borisov's and Kubelis followed AMRI. There's been another decision, Sabihat and Sabihat, which was a Superior Court decision, which also followed the rationale of the Court of Appeal and AMRI. But the court also considered the issue of a pending refugee claim in a non-Hague case in MAA and DEME, which is a more recent 2020 decision. And that was a case involving Kuwait and Jordan, where at first instance, the children who were a bit younger were ordered returned, despite the fact that they had raised issues of family violence with respect to their father. And despite the fact that there was evidence from the OCL, from an expert, a psychologist, and a previous voice of the child report. And that evidence was not considered by the first instance judge. And so the Court of Appeal determined that that was an error, and that the fact of the pending refugee claim, which still hadn't been decided by the time the case went up on appeal, meant that there could be no order of return. That would violate the children's right to non-refoulement, which is an international customary legal principle, and as such is non-derogable, which basically says a person cannot be returned to a country where they've been determined that they would face persecution, or where there's a risk that they would face persecution. So that means asylum-seeking children can't be returned until there's been a decision on the refugee claim. Now, the Court of Appeal in MAA also said that that doesn't mean the family court can't hear the return application. It can, but it can't order return until there's been a decision on the refugee claim. And if the family court decides that there isn't a risk of serious harm, and then there's a positive refugee determination, the family court will need to revisit its original decision on the basis of that positive refugee determination. If the family court decides that there would be serious harm, then it can go on and determine the parenting issues without necessarily waiting for the decision on the refugee claim. So the issue of refugee status and an outstanding refugee claim clearly has an impact on these cases and needs to be considered in terms of the ability to return, and the return can't be effected until there's been a decision on those claims.
Thank you so much, ladies. I guess 30 seconds or less, because we're coming to the end. What should parents and family law professionals consider if a parent wishes to travel with the children to a country that is not a part of the Hague Convention?
Ask your bailiff, even if they're a Hague Convention, don't let them go. No, I'm kidding. But be aware of these issues. Justice Victoria Starr was abducted when she was a child by her father to Iran. And she wrote an incredible article about preventing abductions. And they included a whole bunch of tips, including she didn't know how to phone home. I mean, in today's day and age with cell phones now, it's slightly different, but make sure your children know your phone number. Teach them how to phone home, and so there was just practical tips like that in her paper. I know there was a question about property, joint property in Canada, things like that. If they're traveling, look at their ties. What's their immigration status or citizen status? Do they have family or strong ties to the other country, to this country? Do they have strong ties to Canada? Is there property in Canada? Are they selling their property? Are they quitting their job? Are they unemployed? Are they there are some countries in which you need a father's permission to enable the children to travel, or for the wife to leave to travel. Men can create travel bans in a way that women can't in some countries. So be aware of these issues. Be familiar with the laws and customs of where the child is being taken. Is it a father protecting legal regime? And then if there's high risks, think about various things that you can put in place, right? Only supervised visits, requiring the posting of a bond by a traveling parent, so that the joint property in Canada for the Indian abductor or the abduction to India, get an order to. I had a mother put money into a bank account, $100,000 into a bank account, and if she failed to return on such a day, the funds could be released to dad to go and chase mom to be able to return. So ask for those funds to be part of your chasing. That's what the posting of a bond is meant for. But police enforcement terms, securing passports or other travel documents involving border control, you want to think through some of those issues. That's the best. I don't know if you have any other tips for traveling parents to non-Hague countries, Kathy?
I think you pretty much covered it off, Farine. I think that the bottom line is that once the child goes, you're in tricky waters, potentially, if the taking parent is not interested in coming back. If you're talking about Hague countries, habitual residence could change at some point, regardless of the intentions of the parents at the point at which the child left. So I think what Farine suggested, those are some of the precautions you can take, but none of them are necessarily airtight. yeah, I mean, you can do what you can do, but there's always a risk once the child is actually out of the country.
Thank you so much, ladies. You had mentioned, Farine, the Justice Victoria Star article. I'm just trying to find it quickly. Do you by any chance have a copy of it that we can include with our show notes? It sounds
Absolutely.
really interesting.
So we'll just get her permission, which I'm sure we'll get. And absolutely, we will, as in addition with our case notes, we'll ask Her Honor for her paper on how to prevent abductions. It's at least a decade old. It was before she even became a judge. I think she became a judge 2012, so 2011-ish, but I'll absolutely get it.
It sounds wonderful. Thank you so much. And then very lastly, one of our quick ones, Kathy, I don't know if you know about a BC case. The Supreme Court of Canada denied leave to appeal the father's criminal conviction. Did you hear about this one? Someone's asking about?
It's been in the news about a week or so.
I have not.
Well.
It's been a busy week, but for
Don't worry, I guess
thing
we'll
about
all
it,
be
go
heard.
ahead.
No, I don't know with this one either, but I guess we'll all be learning about it soon.
The Supreme Court denied leave to appeal a father's criminal convictions because of an improper removal of the child from Canada. It appears to be an abduction to Iran, but the daughter is happy there and wants no contact with her mother in Canada, but it's been many, many years, some years ago, and left her there. So the BC Court of Appeal increased the trial court's sentence, the father's sentence, from 2 years to 20 years. We'll look into it. Neither.
Yeah, I mean, it sounds like a clear sanction of the father's abducting behavior.
Excellent. But thank you, ladies. This has been such an interesting conversation.
Thank you for moderating. Thank you for having us.
Yes, likewise.
Thank you, Farine, Kathy, and Michelle.